Judge.
So you'll have 3 minutes to open and 2 minutes to close, and if everybody's ready, you can begin when you're ready.
Wonderful, thank you. Good morning, everyone. It's good to see you again. I think it was about 6 months ago that we last talked. Just to give you a brief reminder about my background, I'm currently a circuit court judge in the 9th Judicial Circuit. Before that, I was a board-certified construction lawyer at Holland & Knight for almost 14 years. And before that, I worked at the Florida Legislature. I was a staff aide and legislative legal intern for the Senate Judiciary Committee and the Senate President's Office. But I think probably what you're most interested in, if I was guessing, is what has changed in the last 6 months since we last talked. And I have been on quite the roller coaster. And I guess being here today shows you that I'm willing to stay on it for another round and see what happens. Right after we met, I think that was in March, in April, I moved over to the Family Law Division of the Circuit Court, which has been a great experience. I love learning new areas of law, and I think it's really rounded me out as a candidate for this position because now I have experience in civil, in criminal, in juvenile, as a GAL, and now on the family court bench. The second thing that's changed is because of your faith in me. I was one of the 6 candidates that was sent up to the governor's office, and I had the opportunity to prepare for and meet with the governor's office for this position, and my husband still makes fun of me because I was having a blast on the weekends, reading all the cases and really finding constitutional support for my judicial philosophy and how I tackle solving problems. So I enjoyed the preparation for that interview, and I thoroughly enjoyed the interview process. And then probably what you're most familiar with is how I spent my summer, which is campaigning. The day after my interview with the governor's office, my opponent drove up from Orlando to Tallahassee and switched races from the race he had been in for almost 8 months to run against me. And so I spent my summer campaigning, and I can't wait to share that information with you about that experience if that's something you're interested in. But really what's most important is your questions, and so I welcome them and I look forward to it.
Thank you. Lee?
Good morning, Your Honor. I was honored to vet your application. I think the panel would be very interested in knowing you were one of the 6 folks we set up last time. Do you have a thought as to why the governor didn't choose you?
Well, first of all, I think it's important to give credit to Judge Lambert. I mean, he's an excellent judge. This committee set him up 6 times. He's very qualified. So I don't want to take anything away from Judge Lambert because he's very qualified and he's a great judge. But what I believe happened is that I was no longer a viable candidate once I had an opponent. My opponent filed against me the day after the interview. He told me because he thought I was going to get the position, and that in a few weeks I would be an appellate judge and he would be a circuit court judge and we'd all be friends. What happens is under the case law that exists, once somebody qualifies for an election, the law favors an election rather than an appointment. So once he qualified, before that Friday deadline of qualifying, which was May 2nd, if I had been appointed by the governor's office, he would have become a judge without going through the vetting of the appointment process or the election process. He wouldn't have had to campaign. He would have become a judge automatically. And I actually informed individuals who were supporting me at the governor's office about that case law and what would happen if I was appointed before qualifying ended. Since he had already qualified, he'd walk into the position. And I respect the governor's decision because I like Judge Lambert, and also because I think it's important for the people in my circuit that they have a judge who sits on that bench who has been vetted one way or another.
Just out of curiosity, you spent a weekend studying up on...
A couple weekends.
Couple of weekends. So, as lawyers, we study too when we go to court. And
I heard that.
many times, we overstudy because we don't know what's going to happen.
Uh-huh.
So did that happen to you? How useful were these weekend sessions when you got up to the interview? Because it's you went twice. You made the cut, right?
I made the cut from here, and then I made the cut to the governor's office. I did not make the top 3
Right.
because by that point I had had an opponent.
Correct. But I'm just curious to know how the interview went, how you, what you thought of the process of not getting from this point, but once you were in the governor's office in the interview process, I would just like to hear your views of how you thought it went, what the process was like for you, and what types of questions you were asked.
Sure.
Vis-a-vis the study that you did.
Right. Please don't think bad of me, but I had a blast. I mean, it was very akin to having an oral argument again, to be able to say, you know, this is my position, and here are the authorities that support it. And I enjoyed that give and take during the debate. As you know, the governor's legal staff and his attorneys are very smart and very bright, and so it was a very engaging conversation, and it was really entertaining. So I enjoyed that. I thought the interview went really well. There were some very challenging questions that really tested your judicial philosophy, how you reach decisions. I didn't get the horse thievery question that you hear from a lot of candidates, but I was prepared for that discussion. So it was, and we even had some jokes about the horse thievery question. So I enjoyed the process. I thought it went really well. I felt very positive after the interview. They asked me standard questions, such as what is your judicial philosophy? How would you interpret, you know, this particular legal issue? Not, you know, the steps you would use, not the conclusion you would draw, because I can't answer that question, obviously, under the canons. And then they asked me general questions about, you know, why I wanted to be an appellate judge. So it ran the gamut, just like here.
Thank you.
Now that your campaign's over and you've had some time to think about it, what did you learn from it, and do you think that it happened for a reason?
Forgive me if I get personal here, but my greatest fear going into the campaign was that it would tear my family apart. I have two small kids, ages 12 and 8, and it was going to be hard for them that Mom was away doing campaign stuff all the time. And all my fears were unfounded. I love my husband more today than I did on May 2nd. He is an amazing man, and he really stepped up to the plate. So I'm sorry I'm being personal, but that's really what happened. And secondly, the kids we decided to campaign as a family. We decided it wasn't going to split us up, that we were going to do it as a family project. And the kids just flourished in the campaign. They actually miss it. And I was tucking my daughter, she's 12 now, and I was tucking her into bed one night. And there was obviously regret that we didn't spend our summer doing what kids like to do during the summer, even though we explained to them there is no constitutional right to a family vacation. But I was tucking her into bed, and she said something about the campaign, and I said, I know the summer hasn't gone the way you thought it was going to go, but I think you've learned some things this summer. What do you think you've learned? And she said, I've learned that no matter what, families stick together, and that it's always important to work hard. If I can send my daughter out into the world with those two values, I think I'm doing a pretty good job. So personally, it was very rewarding. Professionally, the broad-based community support I got was just an affirmation that people really appreciate my dedication to the community. Not only as a judge, but before I was a judge, as president of our 3,000-member Legal Aid Society and the pro bono work and community service I've done in our community. We had over 400 distinct contributors to the campaign, and we raised over $96,000. The only incumbent judge who's ever raised more money than that is our Chief Judge, Belvin Perry, and that was after the Casey Anthony trial in 2012. So I think that shows a significant amount of community support that I was able to garner as a result, I think, of my work on the bench and my work in the community.
So could I ask you the obvious question from the election, which is, so what do you say to the voters who wanted to have a say as to who their circuit judge was, and now they wouldn't potentially if you were elevated?
Sure. I gave a lot of thought to that before I put my name in. In fact, when I got the call from the governor's office in May that I didn't get the position and Judge Lambert got it, they told me on the call that they really were looking forward to seeing my application in July. And I said, you're not going to see my application in July. I cannot apply for this position while I'm actively campaigning. And I felt very strongly about that. When the opportunity to apply after the election came up, I gave some good thought to that. And I came to two conclusions. First of all, everyone that supported me this summer knew that I was on the short list for this job in May and knew that this was an ultimate goal of mine to be on the appellate court. So it's not new information and it's not surprising to anyone. Secondly, I'm serving the same people who voted for me in a judicial capacity. Granted, it's not the circuit court capacity, but it's still a judicial capacity, and I'm still serving the community and the people who voted for me. And third, when I was going through this process, I got so much feedback that people really appreciated my commitment to following the law and my commitment to not step outside the bounds of what I think judges should do, which is rule on the law and not create law. And so I would just be carrying out that philosophy at a higher level.
I have a question. Assuming judicial experience is relevant, how much and what type of experience as a trial judge should a person have to be an appellate judge?
You know, I was always told in law school that you should never use the word should. But
That's the question.
That's the question. Well, my experience is that I've been on the circuit criminal bench for over 2 years. I've handled, you know, your garden variety drug cases to very complex, heinous crimes, such as murders, child molestation, child pornography, child abuse, things like that. So I've handled the gamut of criminal cases, and now I'm on the family law bench, and I've been handling dissolutions, child custody, things like that. There is no requirement that someone have a certain number of years as a trial court judge to become an appellate court judge. I know that that would make your job easier, because then you'd have an objective test. You could say, okay, we're looking for people who have this many years of legal experience, or who know this much information. But you don't come in here and have all the candidates take the bar exam and take whoever scores the highest. You're looking for something more subjective. What you're looking at is someone's temperament, and you're looking at their judicial philosophy, and you're looking at their commitment to the community. And there's no way that you can do some type of mathematical equation that X number of years on the bench translates into someone who would be an appropriate candidate for this court.
Does anybody have any other questions?
I've got a quick one. What's the thievery, horse thievery question?
Yeah.
Oh.
Pardon my naivety.
No,
I'm stoked too.
it's a fabulous question. The question was, if the law said that the appropriate punishment for stealing a horse is execution, would you enforce that law? And the trick to the question is that back in the day, that was the law, is that if you stole a horse, that you were subjected to criminal punishment. So how would you, as a judge, apply that law, and would you enforce it?
Did you try to find that the horse was really a donkey and not a horse?
That would be the art of splitting the baby, wouldn't it? So,
Judge, how long have you been practicing as a judge?
as a judge, I've been a judge since 2012, so over 2 years now. It'll be 3 years in March. But prior to that, I know that there's some focus on, well, you've been a judge for 3 years, but prior to that, I was a board-certified construction lawyer for almost 14 years at Holland & Knight. And as I pointed out in my interview last time, Jackie Griffin, who was a good judge here, a great judge here at the appellate court, she was never a trial court judge, and she had practiced for the same amount of time before she became a judge. So I want to make sure that when you look at my application, you look at the entire body of work.
Do you have any questions?
Picking up on maybe we should actually answer the question to the horse question. What's the answer?
Well, you can get into an arcane discussion of cruel and unusual punishment and whether or not, under the standards of society, whether or not that would be acceptable. But one of the things that I think is really interesting to talk about in terms of judicial philosophy and what you would do as a judge, especially as a woman, is to talk about the 19th Amendment. Because women have only had to have the right to vote for less than 100 years. And you know that there were judges whose wives were suffragettes, whose daughters were suffragettes, who wanted their wives and the women they cared about to have the right to vote. And a judge could not make that decision. I think now collectively we can all decide that women have the right to vote, that that's an appropriate right for women to have. But a judge doesn't have the authority to do that just because a judge thinks that's the right decision. Instead, we have to go through the constitutional process of taking that to the people and allowing the people to amend the Constitution. So I think that's a really interesting area to discuss as far as judicial philosophy.
On the same vein, there's been a series of decisions, that I don't think probably haven't come before you, where the courts have taken the position using the access to courts argument, the equal protection argument, and effectively nullified the acts of the legislature when the legislature has limited remedies to different tort remedies, workers' comp. What's your position as to the relationship between the legislature and the courts, especially when the courts are starting to use that methodology to limit legislative rights?
I have a real concern about that, and in particular, I believe it was the McCall opinion that was issued, and Justice Terry Lewis, who I respect, he's very bright. I had some problems with the opinion in that case because it relied on legislative intent. And what he did during the course of that opinion is pull out pieces of testimony that was given before the committee and statements that were made by legislators during the voting process and during the committee process. I worked at the Florida legislature. I wrote some of those staff analyses as a 22-year-old. My opinion as a 22-year-old should not govern legislative intent, nor should it be the basis for finding an opinion. We don't know why legislators vote for whatever reason on a piece of legislation. And for us to impose their intent on them, I think the appropriate objection in the courtroom would be speculation. I think what's interesting is if you look, I think around that same time, there was another opinion that was issued. The name starts with a D, but I don't remember the name exactly. But Justice Kennedy wrote a dissent in that opinion. And what was interesting was it was on the interpretation of pregnancy and discrimination laws related to pregnancy. And what was interesting was in the statute that was being interpreted by the Florida Supreme Court, the legislature had written their intent into the statute. So there was no confusion as to what our intent is because we wrote our intent into the statute. Is the intent of the Florida legislature that this law be interpreted broadly, blah, 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 blah. So you're not reading intent when it's right there in the statute. But if you're going back and looking at committee reports that some kid like me wrote, or you're looking at comments that legislators gave on the floor for whatever reason, I don't think that's an appropriate basis to make a decision.
Anybody else? Okay. You have 2 minutes to close.
Oh, thank you. Thank you for your time. You all had stacks of applications to look through, and I know some of the applications you've seen before, but some people had to review them all over again from the beginning, so they had some late nights reading all those. So thank you for your commitment. Something I realized during the campaign process is how much faith our voters and our communities put in each of you. They put faith in you to vet the candidates, to spend the time learning their backgrounds, learning their judicial philosophies, really learning their hearts to see if they would be an appropriate servant for our community. Our constituents depend on you to be the gatekeepers for justice in a lot of ways. And so you have a lot of responsibilities, and you've taken those on graciously, and I want to thank you for your service. And thank you for the time that you spent getting to know me.
Thank you.
Thank you.
Appreciate your time.